case briefs, and so much more. LSData's got what you're looking for.
In 1992, the Court of Appeal of the State of California heard the case of People v. Wimberly, which called into question whether certain hearsay statements were admissible in court. The case involved a residential burglary and grand theft that took place in July 1990. Detective Osman, a 12-year City of Monterey Park police officer, testified at the preliminary hearing regarding his follow-up investigation, which included speaking to the victim, reading the crime report, and talking to Officer Jan, the report's author. Osman also testified about statements the victim made, but these statements did not directly connect the defendant to either crime. To establish that connection, the district attorney relied on statements from Mr. Schiro, the manager of the apartment complex where the victim resided. It is important to note that while Officer Jan had spoken to Schiro and included his statements in the crime report, Detective Osman had not. Despite being a properly qualified investigating officer, the Court of Appeals sided with the defendant, stating that the multiple hearsay statements were inadmissible. The defendant's Section 995 motion to set aside the information was granted. Ultimately, the court affirmed the order setting aside the information due to Detective Osman's testimony containing double hearsay and prejudicial statements. The court ruled that Proposition 115 did not permit non-investigating officers to testify without personal knowledge. Admissible hearsay testimony was limited to qualified investigative officers to avoid constitutional questions.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.